It's about 11:06 a.m. and it's June 9th. This is the Community and Economic Development Committee meeting. And so we'll start with introductions. I'm the chair, Pete Peterson. And Mr. Cross, introduce yourself.
Yes, Kevin Cross, District 2, on the phone.
Okay. Anyone else? All right, well, we'll go ahead and start with new business. We're going to discuss a new AO about the Title 21 appeals cleanup. And so, Mr. Ryan or Mr. Whitfield, are you?
Yes, thank you, Mr. Peterson. Dave Whitfield, with the Planning Department. We're excited to present this ordinance to you this morning. With me is Quincy Arms from Legal, and obviously Craig Lyon, Planning Director. This is an ordinance that proposes amendments to Anchorage Municipal Code, Title 21, Title 2, Title 4, and of course the Anchorage Municipal Code of Regulations, Title 21, with the intent of simplifying the process for appeals of land use decisions. Over the past few years, the municipality and more specifically the Planning Department has seen a substantial increase in land use appeals, and this has shed some light on areas for improvement. The Planning Department has worked closely with the Assembly Council and Council for the Board of Adjustment to begin this process, and has circulated this draft ordinance to a number of different boards and commissions. The Urban Design Commission, the Planning and Zoning Commission, the Plating Board, and the Board of Adjustment have all reviewed this particular ordinance and have offered amendments and their recommendation of approval to the Assembly. This version of the ordinance presented here today combines code amendments proposed by the Planning Department and the Board of Adjustment with resolutions of support from those boards and commissions. I'm going to go ahead and turn it over to Quincy Arms, who's going to go through the major changes that the ordinance accomplishes. And at any point in time, if you have questions, please interrupt us and we'll answer them for you. Go ahead, Quincy.
Okay. Hi, I'm Quincy. I have been working on this for 2 years now?
Yes.
It's been a really long process, but really what it boils down to just 5 major changes. I know it's 20-something pages, but they're all actually pretty small amendments. The first big change all has to do with changes to the plating board process, because as Dave mentioned, we've had a number of appeals. They've all been to plating board decisions. So number one, we thought it would be helpful if we could make the plating board process look just like all of the other land use boards. So instead of the plating board issuing what's called a summary of action, they will now issue a resolution with written findings just like the other boards. So it's hard to point to a page number and a line, but you'll see those changes throughout. The second big change is a bit of a shift in responsibility from the clerk's office to the planning department. So before, what we had was the the clerk's office taking in the appeal record and the transcripts and trying to do all this work from the very beginning, and they don't have as much familiarity with these actual boards because it's the planning department that's staffing these boards. And so they weren't as able to answer questions, and they would always be calling the planning department and saying, what am I supposed to do here? So we decided to just put all of those tasks on the planning department, which I'm sure they love.
We're accepting of those tasks.
They're accepting of those tasks. And so there'll be less having to go between the two departments. So that will be helpful.
And just to add to that, I think that provides clarity, not only to an appellant, but to staff and property owners that is the subject of an appeal. So I think it provides clarity across the board and simplicity.
Right. Along with that shifting of responsibility, there's going to be a new player in the game, which is going to be Dean Gates, or Assembly Council Office, so whoever that extends to. They are going to now be taking in appeal briefs and other motions instead of the clerk's office having to take them in and process them. So a lot of time with these appeals, you get motions other than just the brief. You're going to get motions for an extension, clarification, all sorts of stuff, and it's been a lot for the clerk to have to make these kinds of decisions about timeliness and things. So we're going to involve Dean's office a lot more, and he's going to have all the legal expertise to make those kinds of decisions. Also, throughout these changes, you're going to see the requirements for what's needed in a brief are explained a little bit better. We explain proof of service a little better, and yeah, just made it read more like court rules instead of how it was, which was more informal. Because the Board of Adjustment really has a big job acting like an appellate board, so we needed to have it more spelled out. Let's see, last big change is we removed what's called new evidence or changed circumstances. And that was like a separate kind of appeal route that a person, like an interested party, could go down. And in practice, it was fraught with confusion. A lot of times especially in the plating board realm, or I guess only in the plating board realm, we had appellants trying to go down two tracks. They were trying to file new evidence, change circumstances, and then 2 days later file an appeal based on the same grounds. And there were all these, it was very confusing to figure out, now does the appeal stop while we decide this other track? And there was it just was too confusing and doesn't provide really anything that an appeal doesn't provide. So
Do you think that there were some people that were using that as a way to delay action on this by
it's possible.
just creating
Delay or like get 2 bites at the apple.
Right, that's when I was reading it. That was the thing that came to my mind.
And
Either they're trying to buy some more time to get more people in the neighborhood involved, or
Perhaps.
informed, or whatever.
Or maybe they just purely just honestly didn't understand what the 2 different routes were meant for, and so we just made it simpler by providing one.
There could be that possibility, Mr. Peterson. There also, in this change, is the complexity of it all, reducing that complexity by removing the new evidence change circumstances and making it one appeals process. We're making it a simpler process wherein any appellant would still have the ability to make the arguments so that there's not 2 processes, which, as I said before, creates confusion, or what Quincy said.
But if it does actually turn out that there have been changes, or they found additional information, which I suppose could happen, so then they would file a new appeal? Is that a new case? Or?
If there are changes or new evidence, that could be presented as part of the appeal. That could be part of the argument for appeal. It's not necessary to make an argument for new evidence change circumstances as well as an appeal, because the appeal can handle all of that.
Okay.
So we removed that confusion.
There's also the opportunity for any board members to still raise a reconsideration vote. So if it's something that comes to light in the middle of the case, so that's an option.
Yes.
The last thing, or one of the last things that I had I'm just following along in the Assembly memorandum, is along with all these changes we made to code, we then had to dig into the Code of Regulations and make corresponding changes. So you'll see those, and they're real small, just clean up and removing new evidence change circumstances.
I would say that one of the problems that we had with the existing regulations is that Title 21 and the Code of Regulations did not read the same way, which led to, or I should say, added to the confusion. So what we're doing here with these changes to Title 21 is also updating the Code of Regulations so that they read the same way, so as to, again, eliminate or at least reduce the confusion.
The regulations provided a lot of confusion.
Yes.
The last category of things, so Dave was explaining the process we went through, and Title 21 requires it. If we have an ordinance that's going to affect the duties of a board, we send them to all of the different boards and commissions that they affect. And this ordinance mostly affects the Board of Adjustment, and so of course we sent a really early draft to them. And they provided their entire marked up version, which we incorporated, except for one tiny change, so I'll just explain that as well as I can. The Board of Adjustment would like to remove what's called a notice of intent to appeal, and it's always been in, it's an existing code, and what it requires is following the hearing and decision on the record. So the night of the meeting, 7 days?
7 days.
7 days following the hearing, we require would-be appellants to file a notice of intent to appeal. And you want to explain kind of why we like that process? And
So what this process does is it puts the planning department and an applicant or a property owner on notice that we have a forthcoming appeal. It allows us to be prepared for that, to make sure that we have the necessary resources, because in an appeal process, there's a lot of resources, a lot of work that goes into processing that appeal. And so by filing the notice of intent to appeal, I can then allocate those resources to ensure that somebody is available to process the upcoming appeal. So I like the process. I think it was the intent of the Board of Adjustment Council to remove that, as they saw it not necessary. However, I see it as a benefit to the planning department and very likely property owners.
so that's really the only notable difference in what's called the Board of Adjustment version when you look at the entire package, which we don't have here. Another thing the Board of Adjustment added, which the planning department is totally fine with, is just an update to Title II, I believe, where it describes all of Assembly Council's duties. So we're just going to add this new job into code, so it's very clear. And the last thing that the Board of Adjustment recommended adding was an amendment to specific Board of Adjustment provisions that will provide a way for the Board of Adjustment to meet and decide routine motions like extension of time without having to call a public meeting. So, and that is very much in line with any other court. They never have to have a public meeting to decide motions. So the main appeal, of course, will be held as a public meeting. And that's pretty much it. I mean, that is it.
That is it, and we're happy
I didn't
to
leave
answer
anything out.
questions.
And do you have any questions, Mr. Cross?
Not necessarily. I've read through it, and it's my intention to reach out to some individuals that have been through this process to get their thoughts on it. They have wrapped my head around the problems that we're trying to resolve, but having not personally been through this process, it's hard to understand the challenges involved in it. So my intention is to speak to a couple individuals who've been through the process before it lands in the assembly for that. But no, great work. I appreciate it.
Yeah, and I should mention, because Mr. Cross, has the intent of reaching out to certain individuals, we have approached the Anchorage Home Builders Association. They're obviously not here today, but I would expect that they will be in attendance for the public hearing and can offer their thoughts.
Yeah, that was who one of the organizations I intended to contact, but I really appreciate that. Thank you.
Yeah, I mean, we meet with them fairly routinely, and this is something that was brought up at their last meeting, so.
All right, great. Okay, thank you, Mr. Cross. Well, when I was reading through it, I noticed that there was, they were talking about the fees that were charged, and if I'm remembering right, it seemed like originally the fees were totally waived if they won, but now it's being reduced to 50%.
I believe that if the appeal overturns the decision, then the fees are entirely waived. If the appeal is successful in part, then half of the fees, I believe. Is that
Okay.
correct, Quincy?
I can't remember. That was something the Board of Adjustment added. Let's see if I can look.
I read that through that a couple of times. It wasn't 100% clear.
Well, that's not good.
What that was.
We want it to be clear. No, I can't find it. I know we changed, instead of it being a bond, it will now be a deposit. Let's see, where is it? Okay, the appeal fee shall be returned to the appellant if the decision of the lower body is reversed in whole, and 1/2 of the fee shall be returned if the decision is reversed in part. I suspect that won't come up very often. I mean, courts do reverse in part sometimes, but I've literally never seen the Board of Adjustment reverse in part. So I think we're just trying to foresee potential problems,
I see.
but I can't imagine that will come up very much.
And so, what is the fee for this? Do we?
Oh, that's not included. We didn't change the fee, so I don't.
The fee is, I believe, about $1,000 to appeal.
Okay. So, did you have any comments about this, Mr. Lyon, or any information, or? Okay, all right. Well, I think that's all the questions that I have at this, so far. I'll probably have to take another look at this. But I certainly appreciate the presentation today, and it's unfortunate that Mr. Gates can't be here. I think he's gone on vacation for another week, is it, or is he back next week?
He's back Monday.
Back Monday.
Mr. Gates had the opportunity to review the ordinance.
Yeah, Mr.
Oh,
Gates
yeah.
has seen this several times. He was involved from the beginning, so
All right.
he'll be helpful. And if there are other things we could do a better job explaining at the work session, please let us know. We weren't sure what parts you were really going to be most curious about, so we just tried to do an overview.
Okay. All right. Let's see. I don't have a list of any ongoing business. I think it's been over a month since this committee met, and we're old business, so I think we're up to the point of audience participation. If there's anyone in the audience that I don't see here that would like to participate, you could come off mute. Is that, I think it's *6.
There's a couple of people online, but
There are a couple people on the line. So anyone on the line that would like to make a comment, to unmute is *6. Going once, going twice. If there's no one that wants to comment, I guess we'll adjourn this meeting. Thank you.
Actually, actually, Kevin Cross here. Oh, you already adjourned?
Oh, go ahead, Kevin.
We can unadjourn.
Yeah, I just had, just real quick here, and maybe you can point me in the right direction. I don't know if this is a Title 21 issue, there's a code issue, so perhaps this magnificent group of individuals and voracious problem solvers can assist. When an individual purchases a property, they may run into a situation where their old outstanding building permits that have been opened and have not been closed. Some may be 12 or 17 years old. And maybe they buy the property for cash or for whatever reasons. And then in the future, what happens is they're looking to do a refinance or do something, and so they get these conditions, these permits need to be closed. The problem is that in order for the municipality of Anchorage to respect the new owner's right to these permits to close them, they require a notarized letter from the individual who opened the permit in order for any action to be taking place. Problem is, when these are 12 and 17 years old, I've known individuals who've come to me and said, this individual who opened this permit is not even in business anymore. They closed down 6 or 7 years ago, and yet there's an open permit. So I'm curious on what is the best way to assist or what needs to be done to revise code when we have these, and we know that we have a prolific problem with permits that have opened, that have remained open, not been closed for whatever reason, and they may go years. The property transfers hands, goes through to get title insurance or whatever, but now the new owner wants to close these permits, but they may have contractors that are no longer in business. And there's not really a solution for that. It's pretty much, well, that's just too bad. In a particular case, I know an individual that had to find a guy that left state and had been out of business nearly 10 years, and then get that gentleman to drive to a place to notarize a letter to transfer the permit from a business that no longer exists, just so that they could then transfer that permit to another contractor or have the muni come out and inspect for work that was never done. They opened the permit and then never did any of the work. And yet it held up title, it held up loans, it held up everything. So I'm kind of curious on what we might be able to do, a provision or who needs to address that when a new owner takes place, that their ownership, their recorded record of ownership of the property should be adequate to those permits or the authority to dictate and order inspections should be afforded the new owner. I mean, it's recorded. They obviously had to go through a notarized process in order to transfer ownership and the rights of ownership, and yet it seems like those rights of the permits do not transfer to the new owner, and therefore there's a bottleneck in this difficulty. I don't know if that makes sense. I don't know if or if you know what I'm referring to, but perhaps you can direct me if this is a Title 21 issue, if this is a code issue. How do we resolve this so that individuals who are buying properties are not running into a major bottleneck with old open permits?
Do you have any idea on that, Mr. Whitfield?
Yes, and thank you, Mr. Cross, for the question. This is something that we have experienced here on occasion. Unfortunately, specifically, I don't know where the changes would need to be made in code to fix this issue. It is an issue that we're aware of. My recommendation, because this is a Title 23 issue and not a Title 21 issue, is to approach the Development Services Director about looking into appropriate changes to address the issue. It is something I've seen in the past. It's been problematic. But where the appropriate changes are to fix the problem, that would be better addressed with the Development Services Director.
And that's Mr. Trombley.
It would be Greg Soule and probably Adam Trombley, yes.
Oh, I know where to find them. Thank you.
Thank you, Mr. Cross. Well, and I thought, and it probably depends on the permit, but I thought there was a time when you get a permit, you have to do the work within a year or a specified period of time, or you have to apply for
Correct.
a new permit. Isn't that correct?
Correct. Yeah, the expiration of the permit is typically a year unless you extend the permit. I think what Mr. Cross is finding is that lending institutions or title companies, as part of the sale of a particular piece of property, are holding up the sale because there's outstanding permits that have yet to be closed out. So while the municipality might recognize these as being expired permits, the title company expects them to be closed out before the sale of the property. Is that correct, Mr. Cross?
Yes, or let's say they opened a permit. In a particular case, like I said, it was an electrical permit. It was done for, I think, electrical demo, and the work was never completed. And it showed it as, and that's, that's correct. It's showing it as expired, But essentially, you can imagine any organization is wondering, well, did they begin the work and was it not completed adequately? An expired permit leaves a big question of whether or not the work is completed or done. But the new owner can't just call the muni and say, hey, can you drive out here and take a look at what was done on this expired permit? They'll get ignored, and they'll say, well, you don't have any rights to that permit. And my argument would be, you are the owner. Your name is on title. If anything happens, you're the one who's liable and required to carry insurance on the property. The municipality should respect that ownership. And although the permit may be expired, you own the property. Is there a way that they can still get someone to come out and investigate and say, hey, listen, it's expired, but this needs to be taken care of? Not just, it's expired, we can't help you.
Yeah, Mr. Cross, Dave Whitfield again. I would say that that is an issue that should be brought to Mr. Soulé and Mr. Trombley. I think that we should work on a solution, but it would be them that would identify the exact location of that correction.
Thank you. Yeah, I had a brief conversation with Mr. Trombley before. It was a mild head scratcher as well, so I thought I'd bring it up here just in case. But we will get to the heart of it, and I really appreciate your time. That's all I have. Thank you.
Okay, thank you, Mr. Cross. I think we really will adjourn this time.
Okay.
It's about 11:35. Thank you.